Welcome to Divorced from Reality with Johnny Bardine.
Welcome to Divorce from Reality with Johnny Bardine. Johnny is a dedicated attorney who has been serving the Tampa Bay community for over a decade with a mission to help individuals and families through their most challenging times. Johnny provides compassionate, fierce advocacy in all marital and family law matters. I'm Lisa Mosbey, and in today's episode, we're talking about whether you can move out of the house before your divorce is final in Florida and what that decision can mean for your case. Welcome back, Johnny. Thanks for being with me today.
Thank you so much.
You know, Johnny, this is one of the most common questions people have early on when they're trying to figure out who's going to live where. Is Florida, or actually in Florida, is it legally allowed for a spouse to move out of the marital home before the divorce is finalized?
I get this question a lot, and I find it a little quizzical, because of course you are. You are separating from your spouse and getting a divorce. At some point, you're going to have to live apart, and you ought to, and it gets very awkward. And this happens in some of my cases. It gets very awkward when you're living with a spouse that you're actually in a pending divorce with. So if you can do it, and we'll talk about whether you can or should, or the consequences of that in a bit, but certainly, I mean, these processes are about what's doing best for you and leaving yourself in a good position. And so, if it makes sense to to move out of the house pending the divorce, you ought to. Florida is a no-fault state, and that means, in part, that either spouse is free to live where they want, and there's no legal separation in Florida. And no court order is ever going to require that you live apart or they live together. So yes, it's legally allowed for you to move out before the divorce is finalized.
And a word that often comes up in these cases is the word abandonment. Does moving out automatically hurt someone's case or affect their rights to the property?
I hear that word a lot as well, and I have some good news that that's a concept that abandonment is a concept that has no place in Florida, no fault dissolution. It doesn't exist. I think what happens is that people confuse sometimes the legal definition of abandonment, which pertains to child abuse and child neglect, or criminal abandonment. And those are separate concepts and are near each other in the statutes, but they're not relevant here. Moving out doesn't forfeit your interest in the marital home or any other asset. The house is still a marital asset subject to equitable distribution, regardless of whether you live there or not. So the house would be classified and given a value, and the distribution analysis, all that proceeds independent of who recognizes the home as the marital property as their home, or who is occupying it during the case.
And are there cases or instances that moving out could impact time sharing or custody arrangements if children are involved?
That's a good question, because this is actually the probably the only time where moving out genuinely matters, and it's a question that I spend the most time on with a lot of clients. If you have the children in the home with the other parent, you're establishing a status quo. And I think courts sometimes look at that and value stability and continuity for the children, and that can de facto become the schedule when the court enters a temporary relief, which could influence the final schedule in the final judgment, because I think courts will sometimes look at the course that things have been proceeded on and come to the conclusion that if it ain't broke, don't fix it. But the practical reality is that a parent who voluntarily walked away from the daily caregiving has an uphill battle when the other side points to that history. And you can rebut that in a number of ways, but you're rebutting a presumption, and it could end up backfiring on you.
And then are there situations where moving out is actually the safer or more strategic decision?
If you were in a marriage or a relationship in which domestic violence and safety concerns were present, get out as soon as you can. And if there's any threat of physical harm, get safe and pursue an injunction. The injunction process could include an exclusive use provision to get you in the home and the other spouse out. But the first priority is your physical safety, not real estate. So beyond safety, there are situations where staying in the home is doing more damage than leaving. High conflict households, the children are being exposed to constant arguing, or things like that, or cases involving substance abuse or untreated mental health crisis. That can create an instability and some chaos, and the court is going to frown upon that. And if you are enabling that sort of environment for your children, then I think there may be some consequences for you in the legal action.
And so I kind of set you up for this one a little bit, Johnny. If you do feel unsafe and take your children, let's say it's the woman, because I'm the one asking the question. If the woman feels unsafe, she takes her children. Is there a chance that she would be able to ever move back into that house to raise her children? Would the court see that as an option, or does that marital asset just get divided in both people would have to go find something else to live?
That's a good question. And so, absent a court order granting one party exclusive use of that house, the other party who is left can legally move back in if it's their house and their asset. So there are a lot of practical reasons why that's not a very good idea. But the legal reason is that, sure, if you have to vacate for safety reasons, and then your abusive spouse then also leaves the house, or you get awarded the house temporarily, move back in.
And then if both spouses agree that one person should leave temporarily, no safety issues involved, maybe it's a work-related issue, we don't know what the issue would be. So one person should leave temporarily. Is it important to put some sort of an agreement in writing?
Yes, always, absolutely. And this is where I see a lot of self-inflicted wound. A written agreement, even a short one, spelling out who lives where, the time sharing schedule, who pays the bills, access to retrieving your personal belongings, and and a duration of that time can help prevent a lot of disputes that otherwise come up a few months later. So verbal understandings between spouses going through a divorce have a remarkable tendency to evaporate, especially once if one of the parties get into a new relationship and enters the picture on one side or the other. So if it's not in writing, it didn't happen.
And does that writing need to be by a lawyer? Can it be an email, a text? Does it need to be signed or notarized? Give us a little bit more detail on these.
Yeah. So if you're represented by counsel, and I've had to have this conversation with clients, if you have a lawyer, do not enter into side written agreements with your spouse or partner without without your attorney drafting it, or at least consenting to that. But having an attorney draft a short cohabitation agreement to address the key terms is really worth the modest cost in the long run.
That makes sense. I've heard of cases where this has happened, and I was kind of curious, from an attorney's perspective, what's the best approach? What's the way that you recommend? Because we think, oh, well, we're friendly at the moment. We'll just take care of it. No harm, no foul. But things do change and do shift, like you said.
Yeah, there's going to be a time when you're not so friendly. And if you want to remain on friendly terms, then hash out a written agreement that has clear rights, duties, and responsibilities regarding who lives in the home, who doesn't, who pays for it, where the children are. Get that in writing, get it ratified by the court. You might think that you might be scared off from that tactic because it feels litigious or like getting the court involved. But if you don't do that, then it gets very litigious and the court gets very involved.
And here's another one. I'm going to take you down another, sidetrack here. If one spouse changes the locks or refuses to allow the other back in the home to get clothes or their belongings, what happens if they don't have a court order?
So they're breaking the law. Florida long ago abolished the doctrine of self-help, and that's what that is. So absent a court order granting exclusive use, neither spouse can lawfully exclude the other from jointly owned or jointly occupied marital property. The remedy isn't to break in. That creates its own problems, including potential criminal exposure for burglary or domestic battery, and so forth. So the proper remedy at that point would be an expedited or an emergency motion for access, and if appropriate, a motion for exclusive use to formalize the situation through the court. In other words, to put it in writing, which you didn't have the good sense to do before availing yourself of your own devices. So document everything. Photograph the change locks if this happens to you. Communication between the parties about access to the property, any items that you need to retrieve, and remain civil. And if you can't remain civil, call law enforcement for a civil standby for them to just show up and keep the peace while you recover necessary belongings. And they won't make, this is important, the law enforcement will not make a determination about who has the right to be there. They'll tell you it's a civil matter. But if you find yourself in that situation, you should call a family law lawyer immediately and try to hash that out before it escalates further.
And in our last episode, we talked about temporary orders and how do temporary orders factor into this decision, especially when it comes to exclusive use and possession of the home.
Great question. And temporary orders are the formal mechanism for resolving these living arrangement questions in the near term. So an order granting exclusive use and possession of the marital home, which we talked about last time, sets the rules. So without one, both jointly titled owners technically have an equal right to occupy that house. And as we said earlier in this episode, that can create an awkward situation and an instability and chaos when you could resolve that. So once you have an exclusive use order, the rules are clear and enforceable through contempt if necessary. And if a move out is going to happen and it's contested, a temporary order is how you do it cleanly. So if by agreement, you can convert the written agreement into a stipulated temporary order, which gives it the force of a court order, that's meaningful work. And that's going to help you guys out in the long run.
These answers have been great because it's really confusing on what to do, what not to do. Do we need to do it legally? For someone feeling overwhelmed and considering leaving quickly, what is the smartest first step before making that move?
These situations are overwhelming, and it's hard to compartmentalize all the stress, and everything feels urgent all the time, all at once. But that doesn't mean it is. And so talking to someone with some perspective can help you settle down and make a good decision for yourself. So talking to an attorney before you do anything irreversible is a good idea. The attorney needs to hear about the children, the finances, the safety situation, the housing options, and what you actually want the post-divorce picture to look like. And again, if there's a safety issue, contact law enforcement and, if necessary, pursue an injunction first. And that's not just for cases involving passive violence. It can be sought when there's a credible, imminent, immediate threat. But if it's a strategic decision, irreconcilable conflict or unhappiness, drift, whatever, you want a plan that doesn't undercut your case before it starts. So the worst version of this is when the spouse who moves out impulsively after a Friday night fight calls a lawyer Monday morning and discovers that they've been handed the other side a powerful narrative about abandonment and a status quo on the children. That's hard to dodge, and this could be hard for your case moving forward. So the smart version is consult quietly, make a plan, address children and finances on paper, and then execute it. So let's think about it. Let's not just react to it.
Managing our emotions. And I know that you help people do that well. It is one of your superpowers. I've said that before. Thank you so much for your insights today.
Thank you so much for your kind words, and I had a good time doing. Thank you.
Folks, thanks for listening to Divorce from Reality with Johnny Bardine. For more information or to connect with Johnny, visit BardineLawFirm.com. Don't forget to like, subscribe, and leave a review if you found this episode helpful. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.